Welcome. This service is provided by freeconferencecall.com.
Please announce yourself.
Testing. We're going to start in just a minute, folks. Good morning. I'm Nick Freudenberg. I'm the director of the CUNY Urban Food Policy Institute, and I teach public health here at the CUNY Graduate School of Public Health and Health Policy, and we welcome you to the first session of this academic year for the Urban Food Policy Forum. And I wanted to make a couple announcements, and then I'll introduce our panelists, and we're going to have a discussion first among the three panelists, and then we're going to invite you to join that discussion and make comments and ask questions. So as a follow-up to this session today, we wanted to invite community organizations and nonprofit groups that have an interest in getting more active in litigation, supporting current court cases, either around government policies around food or looking at corporate practices. And so we'll be holding a meeting in October, and if any of you are interested in participating in that, you can send an email to Ashley, standing in the middle of the room here, and we'll send you an invitation with the details. We hope to have some community groups that can add this to their toolkit and are ready to start talking about some of the issues that are being litigated. I think the potential will be clearer as a result of the discussion today. And then we also wanted to invite you to our next forum in October, where we'll be having a guest speaker, Bob Gottlieb, who was the founder and director of an environmental center at Occidental College in Los Angeles, and he's just written a book about environmental and food policies in the United States and China, the two largest contributors to the current global food system, both in terms of production, distribution, waste, pollution, and so on. And so this will be an interesting chance to look at what are the similarities and differences in these two countries, with a particular focus on a few cities in the U.S. and China. So we hope some of you will be able to come to that. So our speakers today on our panel on litigation as a strategy for advancing food equity are Peter Lehner, who's a senior strategic advisor and a senior attorney at Earth Justice and Environmental, including food organization. Thomas Merrill is the general counsel for the New York City Department of Health and Mental Hygiene and has been active in a lot of their court cases around food. And Margaret Brown is a staff attorney in the New York program at the Natural Resources Defense Council. And I've asked each of the panelists to start by telling us a little bit of how they have used the law to address issues of food policy, and then we'll follow up with some questions. And so maybe we can start in the order that you're sitting.
Sorry, does this work?
Do we need to turn it on?
Okay, now it works. So thanks for being here, first of all, and thanks for hosting this. These forums are terrific and convenient to get to, so I appreciate it. And I would also urge everybody to read the Q&A that Nick put together over there. It actually does a great job describing the use of litigation in food policy, so it was very well done. I'm not sure we have a whole bunch to add, but we'll try. I think I would just start by saying that I think we all know the food system is broken in lots of ways, but a key fact to remember about litigation is only law enforcement. You can only use it when there is a law or regulation that isn't being followed. And much of the food system doesn't have mandatory laws and regulations. There's some of the biggest problems, like the inequitable or unaffordable access to healthy food, there's no right to that. There's no legal mandate that there be such access. So you can't use litigation directly to enforce some of the biggest challenges we face. So often you use what I think of as bank shots, litigation to address issues in the food system that are important and then will have an impact on the broader food system, but might not be the very issue that gets you up in the middle of the night thinking and worrying. And where there are laws, though, we've done a pretty good job. The environmental and public health community have used a lot of litigation. The laws are pretty strong, for example, with respect to pesticides, and there's been a lot of cases to force the either abandonment or restrictions of use on some of the most toxic pesticides, which has impact on our waters, on our farm workers, and on consumers because of pesticide residues on foods. There have been a number of cases on food safety, both by consumers who have been harmed by unsafe food, for example, bacterial contamination, but also enforcing FDA's duty to ensure the safety of the food system, for example, from toxic contaminants and toxic elements that get put into the food during the food processing, which of course is a big deal since 70% of what we eat is processed food. And then there's been a number of cases relating to food labeling, largely deceptive labeling, that where claims made are not borne out by the product itself. And those have all been areas where we've been pretty successful. But as I said, some of the other areas have been less successful. And if you think about where the health harms are from the food system, it is probably less from actual toxics in food, from just the fact that too many people are eating too much unhealthy food. And that's a little more indirect. But there are a couple cases that we're working on right now that do reflect some of these efforts. One of the cases, which has a related case that Tom will talk about, deals with menu labeling, which was required by the Affordable Care Act. And I will admit this is something I didn't know much about until the Center for Science in the Public Interest, our client in the case, came to us and pointed out that people eat now a third of their food, they eat out. And studies show that when they eat out, they eat a lot more than when they eat in. And the difference between obesity and health is a very little bit. And menu labeling has been proven to work. So this is a good thing, and the ACA, the Affordable Care Act, required it. The FDA came out with rules that were repeatedly delayed because of the political process and other things down in Washington. But finally, they took effect, and the restaurants were supposed to comply on May 2017, May 5th, 2017. And on May 4th, 2017, the FDA announced a delay of the compliance date for a year. And this had really two concerns. One is that in many areas it seemed that the Trump administration was delaying a rule with plans to weaken it and further delay it or eliminate it. So it wasn't just the delay, it was the delay in anticipation of something worse. And of course it was the delay of giving this information to consumers, information that consumers clearly wanted. Now, what they did, however, is they did that without following the right procedure. So this may not seem elegant, but this is the way litigation sometimes works. Because they didn't do notice and comment, and because they didn't do this 30 days before the compliance date, they violated the Administrative Procedure Act, and so we sued them. And so again, it was a procedural violation, and I can't claim it's elegant, but agencies do have to follow the law when they make regulations or issue policy changes, and they didn't. So we sued them, and Fortunately not, I guess it was in late August, Commissioner Gottlieb announced that FDA was committed to the May 2018 deadline, which is to say they weren't going to delay it further, and they were going to issue guidance to help the implementation of the rule, but they weren't going to change the actual rule itself, which were some of our biggest concerns. So on the basis of that, we're now, talking to see if we can work this out rather than continue the lawsuit. And Tom's case had a big impact on that. So that's just one example. I can mention some others, but why don't we go to Tom, of how we can use litigation to put pressure, in this case, on the FDA to make sure they don't weaken what is an important food health policy.
I've been thinking about this question since Nick said he was going to ask it, because I'm typically a defendant. So I don't view it as me using litigation. I view it as litigation using me. I'm often getting used. So I joined the health department back in 2006, and truth be told, I kind of bluffed my way through an interview with Tom Frieden, which if I'd known him better, I wouldn't have had the guts to do. And I went and came from the law department. We were talking about this earlier, but I was a litigator. That was my background. And I kind of got lucky because there was this change going on in public health led by Dr. Frieden, where, suddenly he was this proponent of using our resources to focus on the diseases that were killing people rather than, nobody questions if you spend $50 million in one Ebola case, but if you spend a little money on soda, people get upset. So Dr. Frieden was the one who was like, let's see if we can come up with policies that are going to, really attack the chronic diseases that are killing people. And that led to litigation because, we were regulating business and we were regulating food, and that meant we were going to get sued. And it was lucky for me because I was a litigator, and I didn't know the public health at that time, but I did know litigation. And almost immediately upon joining the health department, we were sued over calorie labeling is like the Godfather. There's Godfather 1, Godfather 2, Godfather 3. There's calorie labeling 1, calorie labeling 2, and calorie labeling 3. So we had just done calorie labeling when I went there, and we were immediately sued by the industry, and we ended up losing that case, but we lost it in the best way you could lose, which is the judge telling you how to do it right. And we went back and did calorie labeling 2 and successfully defended calorie labeling. We were the first people in the country to do it. And so in terms of using a policy that's going to lead to litigation, that's going to lead to food change, why we were able to do that is because, there was this gap in federal law that allowed us to step in and to regulate nutrition labeling around restaurants. And I remember we had talks with CSPI and other groups at the time, we did this, and when we won, that led to other jurisdictions doing it, and other jurisdictions were purposely doing it differently, so that led to industry running to Congress to get federal law, which led to the ACA, including menu labeling in 2010, which led eventually to the FDA doing rules in 20-something or other, many years later, and then to many years of delay, which Peter alluded to, and then most recently, the case of Peter talked about, the FDA announced another delay in the implementation of its federal delay. So we made the decision in New York City to go ahead and start enforcing our identical local requirements, even though we knew that was going to lead to litigation, which it did, and which led to the FDA jumping in against us. But that, I think, combined with CSPI's suit, led to pressure on the federal government to. I think they're finally going to move forward next May because of the pressure we put on. And the other thing I'd say about being used as a litigator, my most famous lawsuit, I guess, is the soda case, which is going to be my legacy. I killed the Board of Health. I joke around, but even that loss had a huge effect. I think the attention that soda case drew. Even though we lost the rule, the attempt to limit portion size, and even though we may have impaired the ability of the Board of Health to act in the future, the attention that case drew on soda, I'd like to think at least softened the ground for Berkeley and other things, and actions that are taking place.
And there was a pretty steep drop in soda consumption.
Right, exactly.
Related to the media coverage.
And a change in the behavior of the soda companies in terms of their marketing. So even a loss can have an effect on public health, and I'd like to think that anyway.
I can't help but sorry, Margaret, I work also in Latin America, and if you ever mention Bloomberg, probably the first thing they mention is soda.
My mom calls me, I'm the guy, the soda guy. That's what I'm known in Connecticut.
Even your mom thinks of you as the soda guy.
She liked the roll though. One of the few.
You can hear me through the mic when I talk like this. Great. So Peter and Tom, I think, mentioned two really great points about litigation, and I'm going to talk about another losing but important case, I think. So just quickly, I work at NRDC. We're a national environmental nonprofit, and we were founded just at the birth of the environmental movement in the very early 1970s. And I bring that up because the environmental movement has some very core differences with, I think, the modern food movement, which is that at its start, we passed many seminal laws outlawing, as Peter said, exactly the behavior that we wanted to avoid in the environmental movement. So the Clean Water Act to stop rivers from being on fire, the Clean Air Act to deal with incredible smog in our cities. In the food movement, we don't have many of those same laws that get, as Peter said, at the heart of the issues that we're trying to solve. And in part, that's because it's not the 1970s, and passing a law of the type of environmental laws we passed then now on any subject matter seems nearly impossible. So litigation is a tool, and I think it's a really important tool, and it's one that gives the food movement clout, against food industry and others, but I think it's a limited tool, but a very powerful one. So I'm going to talk a little bit about NRDC's case against FDA to regulate antibiotic use, which Peter knows very well, so hopefully I'll get all the facts right. In 2000, well, let me go back. In 1977, FDA did a finding that the use of certain antibiotics that are used in human medicine in animal agriculture is bad for human health because it contributes to antibiotic resistance. So when you go to the doctor, they say, make sure you take all 10 days of your antibiotic, even when you're feeling better. That's because if you don't take all of your antibiotic, tiny little bacteria that are left, the strongest ones, get stronger, right? You don't kill them all off. So we are getting what's known as global antimicrobial resistance. Here in the U.S., it kills 23,000 people every single year. So huge issue. We realized at NRDC that, and with others, that in 1977, the FDA said this was a problem, and then they did nothing about it. So in 2011, we sued them to compel them to take action based on that 1977 finding. Over a long period of time, many years, we won in lower court and then lost on appeal in appeal court here in New York. And that was very disappointing, obviously. We were asking FDA to regulate the use of antibiotics in animal agriculture, which is really critical to human health. However, because of those cases, both the district court cases and the appeal cases, we got an incredible amount of media coverage on the issue of antibiotic resistance in animal agriculture. Like just huge numbers of media hits. And I think it really raised the issue with funders, with and very importantly with consumers. So in the years since we lost that appeals decision, which was in 2014, we've had huge wins on this issue, actually. As you may have seen in the news, McDonald's, Subway, KFC, not our sort of lead public health actors, have committed to antibiotic stewardship policies, the correct use of antibiotics from their suppliers. 6 of the largest school districts in the country have committed to antibiotic-free chicken for all their students. In California, we got a law regulating antibiotic use. So it's not perfect, right? Regulation, market change is not regulation, but I think we've seen that the litigation here, although it didn't get our initial desired outcome, has been a really important tool in moving the issue along.
Great, thanks. Margaret, I wanted to pick up on something you said, and I think the two of you mentioned it also. I came of age in the 60s and 70s, and the environmental movement and the civil rights movement and the women's movement, and many of those movements used the law, and the Supreme Court and the federal judiciary had a very different look to it. The the legal power of corporations was perhaps lower than it is now. And I wonder if looking today at 2017, what do you think is still possible around litigation, around food? And I understand the point that you all made, and I think it's an important one. There needs to be a law and a violation as a starting point. And as you think about, you know, the Trump administration and deregulation, as we think about some active state attorneys general who, you know, are looking to be aggressive on some of these issues, what do you see in the next, you know, 3, 4, 5 years as the key issues and the key way that food policy advocates could be thinking about litigation? And I'd be happy to hear each of your views on that.
Okay, I can start. Yeah. Well, I came of age in the 1990s, so I don't have quite the same history on all of these, but I'll do my best. I think that there's a really critical role, and I thought this before, the election of states and localities in setting our new laws and policies around food and public health. The same way those, as Peter said, we need laws that can be enforced. They don't have to be federal laws. We can use state and local governments to fill those gaps. In light of the new administration, I think there's also a really important role that we can play in holding them accountable. Peter's case is a great example. Just yesterday, the Organic Trade Association sued USDA for a delay in organic rule on livestock. So it's a very powerful tool to continue to hold the current administration accountable. And I don't think that we'll get sort of a national good food policy in the next 5 years. It would be great if we did. But I do think that we can use our existing laws to begin to think really creatively about these sort of bank shots, as Peter said. And I think that one of the great things about the current food movement is how it brings together social justice groups, environmental groups, public health groups together to really begin to think creatively about how to use those laws. At Justice, at NRDC, at the Department of Health, there are people who have litigated on certain statutes for decades and decades and decades and haven't necessarily thought about how to use them on food issues. So my colleague Nancy Marks litigates on RCRA, the Resource Recovery Act. It's like her favorite statute ever. So beginning to talk to Nancy about food and think, how can we use RCRA to change food policy? I think it's going to be a really exciting way forward.
Tobacco is also an example where there's a body of law that might be useful. I wonder if you know, you said you're often a defendant as representing the New York City Department of Health. And how do you think about, in what cases do you want to keep your head down and not attract lawsuits? And when are you saying, you know, sort of bring it on as a way of, you know, moving things forward?
I like to keep my head down all the time. I think actually, if the risk is, I mean, if it's clear that we're not going to win, then I'm going to say, you know, we can't do this. But if it's colorable and the goal is it's a policy if it's a policy that's going to have an effect on health and it's something that's, you know, viable, even if we are going, you know, if there's a chance we're going to lose, I think it's something we will decide on doing. You know, I think soda being an example, again, you know, we knew we were likely to get sued. We knew that the challenge would be Boreali, which is the authority of the board to do it. I think we should have won still, but I think, you know, the issue was important enough. No one was acting in that area that pushing the envelope and soda was worth it. I should say we're not always, you know, we occasionally are an affirmative plaintiff, and I was talking to Peter beforehand, and tying into the last question, I think I'd like to think that there's some potential for some affirmative litigation in soda around some of the marketing and some of the practices of the industry. You know, the problem with those cases, you got to come up with damages, and that's hard for us in our particular situation, but if you can come up with a claim, that's an area where there may be litigation, and I'd like to see litigation around food.
a couple of thoughts. One is, think about what's on TV. A lot of them are courtroom dramas. Lawsuits do make for good stories, and it's not just a win or lose. How you win or lose makes a big difference. If you have a chance to present the science in a compelling, strong way, but maybe lose for preemption or some other what the public might view as a legal technicality, you might have in many ways won. So there's a difference between losing and really losing. And the second is, in terms of your question of growing up in the 70s, the food industry is, I think it's fair to say, fundamentally different than the other industries that were regulated. I mean, think of the supply chain that went into a breakfast in the morning, where the coffee came from some other countries. If you put milk in your coffee, the dairies that came from. If you had eggs, or imagine if you had bread, the 5 different grains in your bread came from probably 5 different farms in 10 different states, and and all of that managed to get to your breakfast plate. I mean, it's incredible. Compare that to the big polluting industries in the 1970s. The power industry, it was very concentrated. There were a few companies. There were, in that time, fewer than 800 power plants that provided almost all of the U.S. coal electricity, about half the total electricity. 1,000 plants provided all of our electricity. Meanwhile, there were 3 million farms. So there's a reason why the laws why we don't have the same laws for the food system. It's much more diffuse, it's much more complex, it's much more sort of a pyramid of little companies rather than a few big centralized ones. But that being said, there are still some ways. There are some laws that provide some strong statements which agencies haven't really taken advantage of. So one thing that can be done is organizations can petition for a regulatory change, saying this is what the law really requires, and given our new understanding of the science, this is something the agency should do. Now, very often the agency ignores you, so you actually first have to sue them to get them to answer your petition. And then when they're forced to answer your petition, they deny your petition, but then you can finally sue them and get a hearing in front of an impartial judge on the science. And some of the most important environmental policy came about this way. In a different area, the ability of the Obama administration's Clean Power Plan, which was its most important effort to reduce carbon emissions from existing power plants, came about because of a petition in the late 90s. It was ignored. We sued them for ignoring it. They denied it. We sued them again. That went to the U.S. Supreme Court. So there are opportunities to petition FDA or USDA in other circumstances to change some of the rules that implement the statutes and then start a process. It's a long process, but changing the food system is a long time. One example of that we're looking into, and we're actually already in litigation on a piece of it, deals with the food safety exemption for food that is, quote, generally regarded as safe, which sounds like a common, and was intended in the 1950s when it was passed as a commonsensical rule for additives to food like salt and pepper, vinegar, oil, that we all know that's safe. You don't have to disclose it or do a whole bunch of process. But now there are thousands of chemicals, many of which are trade secrets, that the company by itself has decided are, quote, generally regarded as safe, even though they're not actually known by anybody except them. So this loophole has sort of swallowed the whole process. And that's an example where litigation can challenge the existing rule, and a petition followed by litigation can perhaps get us to a better place.
Peter, I wanted to, again, ask you a question. You spent a few years in the New York State Attorney General's office, and litigation around food or other things can be brought both by consumer groups like the two that you represent, but also by state AGs. And what are some of the differences between those two routes? And if food advocacy organizations want to encourage state attorney generals to take up an issue, how might they be able to do that?
Sure. So first of all, some of the state AGs, and we're lucky in New York, are pretty busy these days because I worked there during the Bush years, and Bush gave us a lot of work to do, and I can promise you Trump is giving Schneiderman and other AGs even more work to do. In a consumer fraud case or shareholder fraud case, the AG has a fundamental difference in a private case, which is they speak for the public, and therefore they don't have to have the same showing of specific damages. If you are, as a shareholder or as a consumer, say that you've been injured by deceptive advertising, for example, or a deceptive statement to shareholders, you have to show that you've been injured. You're out the money or you're out something because of the deceptive advertising. If you speak for the whole public, the state really just has to show that the advertising or the shareholder statements are deceptive, and that is frankly much easier because frankly it's pretty hard to show, why did you buy this package of Cheerios or something and add it up to an amount that makes a difference. So the government does have the ability to force change. Now that's not a monetary damage, it's an ability to force change in practices that a private group or an NGO doesn't have. And for an NGO, and from my time both at the city government where I started and at the state government, is they're pretty busy. And so a NGO, if you want to get the AG to take action, it's really helpful to pull together a lot of the case, pull together the facts and have a clear statement of the law and a credible argument why there's a good case here. Because there's a limited number of staff in these offices, and taking on some of these big companies, it's a battle. If any of you have followed the battle between the New York AG and Exxon, that's a big, these companies don't roll over easily. And so the more information you can give with really careful analysis of the science, each stage of why this is a problem, the more likely it is that the AG can use their legal ability, which you don't have, in order to move forward.
Peter, if you want to add anything on that?
Yeah, I mean, the state's a little easier. I mean, for the state, we generally have to prove damages if we're going to bring a case affirmatively. Yeah, the city, correct. And it being a battle is an understatement, because if you take on industry, it just becomes a war. And, the city has brought affirmative litigation around, like in lead. We were talking about that earlier. And that was just, the damages were limited to nitrogen just to kind of limit this discovery, but it took years, and it's resource intensive. It's just incredibly difficult, but it's a route that can be gone.
I would just add to what Peter said, that I do think the AGs have a great bully pulpit to make points about these cases and make clear that X company is in the wrong. Schneiderman's done a great job on that with Exxon, so even, again, in a not necessarily winning case, not speaking about Exxon, but generally not necessarily winning case, we can really help consumers and the public understand and begin to change the tides in the marketplace or otherwise.
I'm going to ask one last question and then open it up for your questions. Part of what led to this session was a conversation we had a few months ago of trying to understand how law organizations and NGOs and food policy organizations and community-based organizations doing food work can better support each other, can better work together. And I wonder if each of you could say something about, how do lawyers talk to community activists and advocates and policymakers, and how do those folks talk to you all in a way that will make it easier to use the law as a useful strategy?
I think the menu labeling case is probably a good example. We had to move very quickly. It was a 1-year delay, and so we wanted to get into court quickly. But one of the things we had thought about but didn't have time really is to work with community groups that have members and have real stories of people saying, look, I really want this information. When I have it available, I use it, and I make choices for me and my family based on this so I can live a healthier life. I've got diabetes, so I'm concerned about the nutrition information, not just the calorie information. Those stories convert a regulation, which is supposedly a bad word, into a protection for our families. Those stories make this real to a judge why this matters. Because on the other side, you have industry saying, oh, it's going to cost us X millions of dollars or whatever else. And unless you have something on the other side, you know, people listen, oh, why impose these costs on people, on businesses? So I think the relationship that is so important is working with the groups who are on the front line, who have the real stories, the evidence of why these protections are important, why these changes to the food system are important. Because it is those real world stories that will make the difference, either in front of a judge or potentially in front of a policymaker like FDA or Congress or state legislature or in the media.
And to add to that, like going back to the policy development, I think it's incredibly important. You know, if we're going to adopt a policy that's going to lead to litigation, not just in the lawsuit, is it important to have community groups involved in the messaging around that policy, but it's important in the development of the policy. I think ultimately we lost the soda case not because of the legal strength of the Boreali argument, but because of the way that the rule was perceived. And we lost the messaging. It was co-opted by the other side. It became about us being a nanny, us stepping on minority businesses, and not about the impact that soda was having, the way that soda was being. It was never a message of the fact that sodas have gotten bigger because the soda industry has marketed them that way. And if we had engaged groups earlier and had gotten them around the rule, I think the perception of the rule, both by the public and by the courts, would have been different, and perhaps the results would have been different.
I think this is a great question, and one of the areas that I look to in this, again, to the environmental movement, is the growth and maturity of the environmental justice movement, and many groups have had a lot of success working very closely with community groups, with environmental justice communities, and representing exactly what they want to be represented on and their goals and what matters most to them. And I think that the same great partnerships can be made in the food justice realm. I also think that lawyers can be helpful to community groups on developing policy, working more broadly, not just in litigation. And I thought I would take this question as a chance to plug the PACE NRDC Law Clinic, which offers direct transactional legal services to farmers, food entrepreneurs, food justice organizations. So if you're not looking to sue Monsanto, but you need a more innovative lease or to be incorporated as a nonprofit, there are lawyers to help with that as well.
Great. And some of those questions are exactly what we hope to pursue in this follow-up discussion in October. And again, as on the flyer on the table there, if people are interested, let us know and we'll tell you about that. So we welcome your questions, comments, and if you can just introduce yourself, and we'll give you a couple mics. I think what we'd like to do is hear 2 or 3 questions. So do you want to start, and then a follow-up, and then in the back there, and then we'll give panelists a chance to respond. Can we have one in the front here?
Thank you. I'm Paula Daniels from Los Angeles. I started the LA Food Policy Council there.
Welcome.
Thank you. And I'm happy to be here. This is a really good conversation. And I have a question about the rights to food. I've been looking it up while you were talking. And there's declarations around the world. The United States is the only developed country that doesn't have it, about the human right to food. And I'm wondering about it as an eventual strategy for enforcement, and whether there's potential for its enforcement. I haven't heard much about enforcement of the human right to water or the human right to food, but I want to mention it just as a point of discussion and recognize that, as you said, Margaret, this time is different politically than it was in the 1970s, which I also came of age during. And if there's not the potential to have a human right to food at the national level, it being that we're the only country that doesn't have it, could this be adopted at a subnational level, at the state or local level, and might there be some potential to use it as an enforcement tool at that level. Wondering what you think about it as litigators.
That's great. Let's hear a few more questions, and then we'll give people, panelists, a chance to respond.
Right here. Hi. My name is Stephen O'Brien. I represent the Urban School Food Alliance and New York City School Food. And good to see you, Paula. My question is really around equity and what kind of legal sort of issues can sort of help to bridge the gap with equity in food. As a professional chef and a food service professional for over 25 years, I see this gap spreading farther and farther apart, both in the retail market and in the institutional market and in the quick serve restaurants, that you have sort of this two-tiered approach to food. Really clean food, simple food, highly inaccessible to the masses, and I think, you know, there's a whole misunderstanding of organic food, etc. I applaud people like Paula who are trying to sort of create a center, you know, for food, sort of food standards, so that people can sort of fall behind the same standards on a national level. And I found it very interesting that you talked about the generally recognized as safe sort of aspect of what the FDA has allowed to happen in the food supply. And I appreciate that you said it's so diffuse and that it is a very hard thing to operate within. So as an operator and someone who's representing millions of meals every day, I'm just curious what kind of things you sort of see on the horizon to sort of close that separation in the food equity as far as the quality of food that we're offering, especially being an operator that works in such a highly regulated and highly resource-starved environment. So just would like you to sort of think about and talk to that a little bit. Because really, when New York City banned artificial flavors and artificial colors, basically in the late 70s, early 80s, and then built on that list to a list that now has, you know, certain types of dose stabilizers banned, et cetera. We're unique in New York. People like Paula are trying to create some standard nationally, but there's school districts all over the country with all these unique standards just because they're trying to represent their consumers, right? So their communities that they're serving. But that doesn't help the industry who has to develop products that we have to buy in over 3,000 school districts in the country, developing separate specs, et cetera. So it makes it very, very complicated for the food industry to sort of fall in line with what our needs are. So just trying to give you a little bit of an example there.
Let's have one more question. I think there was a hand up over there.
Hi, I'm Becky Morrison with U.S. Right to Know. We're doing national nonprofit around food system reform. And I guess my question goes back to something Nick said regarding tobacco and the legacy of tobacco and what specifically the food movement can draw on in terms of litigation in that realm. Is it deceptive marketing? Is it the mere fact of a cover-up? Is it, so anyway.
So three great questions. Right to food, litigation as a way to advance food equity, and what can we learn from tobacco? And maybe I'll just, you know, my first thought on your right to food is in New York State, we have included, it's come to be interpreted that our Constitution includes a right to shelter. And it's not that that's been unproblematic, but New York is really unique in saying that people have a right to a roof over their head, and that has really forced the city and state to do things that other jurisdictions haven't had to do. And I wonder how we can think about that around food, and turn it over to you all.
Well, I would just add, if you could put it in the state constitution, I suppose, but you're absolutely right. The burdens would fall into the cities and the states to comply with that state constitutional requirement. It wouldn't change anything on the national level, and it'd still be, I suppose, national preemption, but you could put more entitlements on the state and city level that they'd have to comply with on if you put it in the state constitution, or even the city charter, perhaps.
First, these are great questions and great ideas to follow up on. There are a lot of people in the public health and in the environmental community looking to more creative litigation strategies because of frustration with sort of our political gridlock in Washington and in many states, and they're trying to find something new. There's a case that many of these focus on climate because of the urgency of that. There's a case using what's called the public trust doctrine, which goes back to Roman times, to try to force governmental action on climate change. There have been some cases to try to get a universal right to a stable climate or a state right. And so those are the types of cases. So I don't have the answer, but it's a really intriguing idea to try to look at some of those more amorphous and general rights that have been embodied in various aspects of Anglo-American law for 300 years and trying to use them. There's also been an effort to try to use the equity argument a little bit. We have a case down in North Carolina dealing with pig farms, and it is actually under the civil rights laws because it just so happens, surprise, surprise, that there's the vast concentration of these swine farms in a county which is predominantly African American. And so we were able to show that there's a disproportionate impact to a protected class under the civil rights laws and make a complaint that way. The remedies are fairly limited, so it's not a slam dunk, but it is using essentially an equity type argument. And I think it's interesting to try to explore further opportunities, especially in the idea of access to healthy food, where the inequities are getting greater and greater, and you might be able to prove a disproportionate impact on different communities. And lastly, on the right to know, you guys do great work, by the way, thank you. I think the whole issue of consumer information is clearly very strong. There, on the private sector, there's the private deceptive labeling cases, and those are being generated by private lawyers. They make money off of it, and there's a pretty constant flow of that, and that can be helpful. But we found other right-to-know cases have been helpful. We did a case and just won a case on emissions from hog farms. And again, people want to know what's there. There's been a lot of interest. Menu labeling is essentially a right to know. There's going to be a battle over the labels, the nutrition facts label that was supposed to have the added sugar line, and industry is saying let's delay that for a couple of years until the GMO labeling comes out, and let's make all of that for naught. And I'm oversimplifying, but anyhow, there's going to be big battles over that. So clearly, information is a really powerful tool, and I think any of us who litigate would love to hear ideas of specific opportunities to litigate that.
Addressing the question about the lessons from tobacco, I mean, certainly on the policy side, you know, I think at the department we draw heavily on tobacco. You know, the same strategies, retail reduction, tax. You know, those are the same types of things that we, you know, think about when we think about addressing, particularly soda. I think that, you know, tobacco is definitely the source of all of the at least policy innovations, and probably legal ones as well, in terms of where to go.
Yeah, I would add on the tobacco question that I think in addition to strong litigation skills in the food movement, we need to keep pushing for really strong investment in science and research on these issues so that we can make the case when we get to these litigations that there's a strongest possible connection between whatever food system ill we're seeking to address and the problem. And I think that we have that, but it's not as strong as tobacco so far. And on the equity question, Stephen's question, first of all, congratulations on universal free lunch here in New York City. I think that's a pretty amazing step in the right direction. I don't have a genius litigation idea for that, but I do feel that the political conversation around SNAP, around school meals, is really beginning to change in our favor, that people deserve to be able to buy the food that they need for their families. And so I think that is actually one area where in recent years, from Healthy Hunger Free Kids and other pieces, that we have seen a move in the right direction on the policy front.
Just one issue I'd like to add before opening up for another round of questions. I think a lot about targeted marketing of unhealthy, ultra-processed food as an area that's ripe both for activism and litigation. And I think when I talk to lawyers about it, they point out the increasing protection of commercial speech as being an obstacle to taking that on in the legal arena. But I think on a moral ground that the right that companies can persuade children who are not fully developed cognitively to consume products that are associated with premature death and preventable illness, that ought to be something that we could take on. And certainly what that court decisions follow public opinion as well as contributing to it. And who would have thought 10 years ago, 15 years ago, that the Supreme Court would sanction gay marriage? And I think the rapid changes we saw in that shows how social movements can change the way that even robed judges in courtrooms think about issues. And we ought to be thinking about what are the food issues around right to food, again, around right not to be persuaded to do something that's going to make you sick and die early. How can we contribute to a change in environment that will make a future Supreme Court decide that that isn't moral or legal? Another round of questions. Yes, 1, 2, 3.
Thank you for this great discussion. A quick question.
Can you introduce yourself?
Oh, I'm sorry. My name is Eddie Abudi with the Aerial Air Conditioning. One quick question. By the fight against the soda companies, it's like a David and Goliath fight. But on the other hand, you have to promote some kind of healthy food consumption, substitute the sugar from soda to fruit. Honeycrisp apples, cantaloupes. I don't see any advertising from farmers or government-sponsored advertising to promote healthy food consumption as a substitute for the sugar in soda.
Nevin?
Hi, Nevin Cohen, CUNY School of Public Health and Urban Food Policy Institute. Just a question about any opportunities for litigation around fiduciary responsibilities or shareholder disclosure of potential liability that food companies may incur. There has been some effort by even the soda companies, I believe, to disclose the potential for regulation to hurt their profits and other opportunities for shareholder efforts.
And in the back?
Hi, I'm Julia McCarthy. I'm an attorney at the Laurie M. Tisch Center for Food Education and Policy at Columbia University. It's a mouthful. I had two questions, and either would be great to hear. First, Margaret, you mentioned that evidence was a big problem, and I was wondering, in a room full of future researchers here at the Public Health School, are there areas where you would like to see sort of deeper or better evidence that could help with litigation? And the second question is, I'd love to know how you fund this litigation, because taking on big corporations and taking on the government is incredibly expensive, and so how do you strategize around that?
Great. Panelists want to comment on some or all of those?
Yeah, I'll start with the soda. So you're absolutely right. It's not just legislating or trying to legislate what how unhealthy food is presented, but there is a role to promote. And sad you haven't seen the ads, because there are campaigns out there that the department has, both promoting fruits and vegetables, both promoting water. We have multiple programs around health bucks where we supplement. We give people going to green markets. They're basically script that you can use, and it doubles your buying power at green markets. We have healthy market programs that we've been committed to. A couple of years ago, we had an initiative, didn't really work as well as it could have, called Green Carts, where there was a lot of data that there were communities in the city underserved with fruits and vegetables. So one idea to approach that was to create a new class of vending. And public health school, they don't teach you this. The two things you're going to deal with if you ever go to health department are animals and vending. So the mobile food vending, very, very contentious thing in New York City. But this was an idea to create a whole new category of vending licenses, allowing people to bring fruits and carts to specific neighborhoods. I said we do have multiple media campaigns. I'll have to go back and talk to our media people if you aren't noticing them. But you're absolutely right. To approach the food deserts is as important as trying to deal with practices of the industry and soda and stuff like that.
I'll answer Julia's questions. They're great questions. Okay, so on better evidence, as I was thinking about that, I realized that I think in part it's better evidence, but it's also the connection of researchers with lawyers. So helping lawyers understand the very long scholarly articles that are published and then sent around that are on password protected research sites. So getting to really help build that science case for us and helping us to understand that. At NRDC, we actually have a science center that's supposed to help us with that. And then on the question of funding litigation, which is actually a really interesting question. When NRDC was first founded, we were denied our 501c3 tax-exempt status because we were a litigation organization, and we had to fight. Our first court battle was with the IRS to get that nonprofit designation to say that public interest litigation was, in fact, a charitable purpose. And I think it is one reason that smaller groups struggle with litigation as a capacity. It's incredibly expensive. It's expensive over a long and sometimes unpredictable period of time. When you're up against the food industry and many other industries, you're up against many of the best lawyers in the country. There was a really great case where a bunch of farmers sued Monsanto for contaminating their fields with GM seeds. So organic farmers said, you're ruining our crop by getting allowing GM seeds to float into their fields. And they lost that case. And the person who represented Monsanto in that case was the former Solicitor General under President Clinton. So we really need to have the very best litigators, which takes a lot of time and money to build up. So, long way of getting to this point, but it's really critical that those organizations. Oh, you
said to keep it really close to your lips. Sorry.
How's this? Okay. So I think it's really critical for organizations that do have broader capacity and longer term capacity to really work with smaller groups to build up their litigation ability.
And taking those three thoughts, there are some creative angles to address the healthy food issue. One that we and others were looking into is using the requirement of hospitals to provide community benefits to maintain their tax-exempt status, which they had traditionally done by serving uninsured people. But with the ACA, there's fewer uninsured people, and hospitals were actually finding that a lot of their treatment costs were from diet-related diseases. And just in some ways, there's an amazing anecdote of, I think it was Columbia, realizing because of people coming in with air-related health problems, that the hospital found it cheaper to go and remediate the mold in people's apartment than to keep treating on them in the emergency room. And similarly, hospitals can find it to actually help better to give what sometimes are called veggie prescriptions, this type of script that Tom talked about, to give people the ability to buy more healthy food rather than keep dealing with the diseases related to an unhealthy diet. That is possible. There are a few hospitals that are doing it at a very small level, but hospitals have in the past spent on the order of $65 billion a year on what are called community benefits. So it seems to me that there's a almost unlimited opportunity for community groups to try to get hospitals to spend more of their community benefit budgets on helping provide their community and service areas with healthy food. It's hard to imagine a better cost-benefit response for the hospital than doing so. As to fiduciary responsibility, it's a really interesting idea. There's a lot of litigation now against some companies for failure to address or disclose the risks of climate change. And one can, and I think there have been some relating to some processed foods. Certainly a company that is largely dependent on sugar, as the awareness of sugar impacts is increasing, could easily face such a case, and it's something to look into. And lastly, on the evidence and the funding, you know, a lot of the tobacco was great because it was so clear, whereas many health-related issues, there are just so many confusing factors. And even with soda and sugar, we have sugar from lots of other factors in our diet. It's not just soda, even if soda is the biggest one. So it's often just the fundamental evidence, but also teasing out that the predominant strain that allows the action. And then there's also slightly different legal standards if it's, you know, 80% of the cause versus 40% of the cause. And lastly, I would say, obviously, funding is an issue. A group like Earth Justice, we're just lawyers, and we represent all our clients free of charge because our clients often small community groups can't afford us. So we do everything on behalf of, we have 400 or 500 clients at any one time, and do it all for free, and we're philanthropically funded, so that's sort of indirectly providing free legal services to the community groups, but it's a really an important issue, and we hope more people understand the importance of litigation.
I would just add on Peter's point about veggie prescriptions. I think that's actually a great example of the kind of evidence lawyers can use to help change policy. So a few pilot programs that are well studied in this kind of thing help spark ideas around how we can use the Affordable Care Act that community groups and others can really help lawyers move these issues forward.
I wanted to return to the tobacco question, and I agree with you that tobacco is different than food in important ways, but I want to emphasize the similarities. It took, 3 decades or more for the tobacco litigation strategies to be successful, and that's because it was a learning process. And when they started, it was not so clear-cut. And, it took a few decades for the science to go from the password-protected medical journals into the public discourse, and we need to think about that. What it will take to both consolidate the evidence around food, and I think the growing belief in the public health research community is that ultra-processed food is replacing tobacco as the leading cause of premature morbidity and mortality in the world today. In the next decade or so, it will be a really important cause, and too much fat, sugar, and salt, are the leading causes of that, and that there is a relatively small number of companies who control the increasingly concentrated, you talked about concentration before, so that might suggest different legal strategies. I think some other lessons from tobacco, the process of discovery of the tobacco attorneys against the industry played a really important role in educating the public and also discrediting the tobacco industry as a legitimate player in setting public health policy. And again, although the analogy isn't exact, I think we need to be thinking about, moving to the place where Coca-Cola and Pepsi and McDonald's don't have a place in setting public health policy. Maybe they have a role in deciding, how best to enforce public health protections, but not in setting that policy. And we need to do some more work, and maybe discovery will help to discredit them as legitimate participants in shaping how we make decisions around food.
I was going to say,
and then I think resources is also, there's a lot of lessons of tobacco. The Master Settlement Agreement brought, billions of dollars into the public treasury to use for the purposes of education and tobacco control. And we ought to be thinking about, in the next decade, how can we use that around food? Sorry.
Oh, no, I was going to say, as important as that you were asking about the science you want people to do, but it's kind of also as important as the science that the industry may already know about that hasn't come out yet, which took forever to come out in the tobacco industry litigation. And you're right, it took a long, long time in tobacco, and if you look back, maybe we are going to go that way, but it's a different world than it was 30 years ago. And not just around the litigation, but the social norms as well. You look back to the Smoke-Free Air Act and how controversial that was in 2001, and that's now, nobody questions the right to go to a bar and not have, smokers there. And, the social norm things are changing too, as we take soda out of hospitals and schools and things like that. It's a similar road, but we're much further down it than we were, and it was a long road in tobacco. I think that's important to remember.
So I think we have time for a few more questions, short questions and short answers. Yes, let's start over there.
Hi, my name is Erica Inwald, and I work with the Domestic Fair Trade Association. I was just curious if you saw any potential for litigation with labor issues in the food industry. I know specifically in New York State, they've tried to pass legislation for fair labor practices for farm workers, but it has been less successful, so they've started a lawsuit related to that. So I was just wondering, either nationally or more locally, what the potential is.
I think there's another hand up. Those of you over here.
Elizabeth Durbus, I'm an attorney. This has sort of been touched on already, but I wondered to the point about the power industry being concentrated in the 70s and the diversity in the food industry, and you just sort of made this point. To what extent does vertical integration across different parts of the food industry create opportunities for litigation, and what would that look like, and to what extent is that sort of offset by the consolidation of industry power within those integrators?
Good question. Another hand up here, and then over here, and then I think we'll see where we're closing. Go ahead.
So my name is Robert Solomon from the Council of Public Health. I just want to follow on Peter's point about difference between losing and losing. So as more and more cable news channels are getting lawyers as anchors, when you start a case or litigation, you think using the media as a source to increase scientific evidence and having lawyers litigate that in front of the court of public opinion, even if you lost in court, there's still a chance of winning in public opinion, and maybe that's a strategy that gets more and more people buy in what the scientific evidence is.
Yes.
Hi, my name's Ingrid Wells. I intern at the New York City Department of Health with actually the Health Bucks team, and I work on the pharmacy to farm prescription program. But my question is in regards to like the recent flexibility changes with school lunch standards and with whole grain, sodium, and milk, and how that's regulation will be shifted more to like a local level. And so when something like that is at the federal and then there's a shift to more state and local controls, what do you think about this current change, and do you think that causes inequalities in the food system?
Great. So if each of you can respond relatively quickly, and also if you have any closing thoughts for the participants.
Well, I think your vertical integration question is a really great one, and I think has incredible power. One of the corporations that run our food system are enormous, and there are not that many of them, and they have harmful externalities throughout their supply chain. So in the case of a power plant, we have one smokestack or many smokestacks, but they're in one location, right? We have sort of a single output. In the case of a vertically integrated chicken company, the harm that comes from that company into the broader society comes at the contract farm level, it comes at the hatchery, it comes at the processing plant, it comes at the consumer health point. So I do think that focusing our energy on these big actors is really critical. I think that addressing their harms is more difficult than it was with certain environmental issues. And then before I turn it over just to speak to the school food piece, I think that we've seen in the school food realm that regulation, or it should be better put as protection, is really powerful at helping school districts move in the right direction. And the small deregulations put forth by Secretary Perdue are, I think, very small, luckily. I mean, others may disagree, but the change in milk fat percentage, the whole grain piece in particular, I think are very small. And the sodium limitation Petition is where we do have really strong science on the negative impacts of sodium on public health, but given the realm of changes that could have been made and the dissatisfaction with the Hunger-Free Kids Act by members of the Republican Party, I think this is a small change. And just to close, thank you so much for having us. It's really been fun.
Likewise. I would just say that using the media, as you said, really is critical, and often lawyers aren't great at it, and that's why the lawyers need to really work with the community groups, have the real stories out there. It's interesting to look, the ballot measures that pass at the state level are often, say, animal welfare levels. People think about food, 3, 4, 5, 10 times a day, and they don't just think, I need 2,000 calories. They care about what their food is. There's huge opportunities here that we have only begun to tap. And the transformation that we've seen in other areas, like the energy system, can go a lot faster, perhaps, because people care about food, what they're eating, what they're feeding their kids, and where it comes from, in a way that, frankly, no one really cares about the energy system in the same way. But the energy system has been significantly transformed over the last 20 years, and so we have this enormous opportunity. But I think the role of the community groups, of people, of consumers, is going to be far, far more important in food system reform. And the litigator's role will be to elevate those stories and put those stories into the legal context. But it all starts with the reality of what consumers are facing.
First, a thank you to our panelists. Terrific discussion. And second, a thank you to you all. Great questions, comments, points, and I hope we can move this discussion forward and use the law more sharply, more robustly to advance food equity. Thank you all very much.